Representing the appellee, the state of Vermont, is attorney Evan Meenan.
All right, counsel for the appellant, please introduce yourself and your client, and then you may proceed with your argument.
Thank you, Your Honors. Good morning. Rebecca Turner, representing Mr. Cochran, appellant. This appeal raises three fundamental errors. First, there were defective pleas for two of his felony convictions below, violating Rule 11F that requires vacating those convictions. Two, there was a separate due process fundamental violation on his trial for felony ag domestic, where the judge violated fundamental rules of impartiality and party presentation issues, and that requires vacation of the conviction. And then finally, third, there was discrepancy in the oral pronouncement of the aggregate sentence of the four convictions at sentencing, and with the oral being inconsistent with the written. And that was a significant difference, substantive difference of 10 years on the max, and so requires correction. I understand with a little bit of time remaining, I'd love if the court could direct me with the particular issues. I would like to start with the most straightforward, which is the 11F factual basis. Of course, this court has been clear in Ray Bridger that the record must affirmatively show that all of the essential elements for the offenses that Mr. Cochran pled guilty to was supported by his admissions. Here, for the domestic assault, there was a failure to establish a protected household member was in play. The state argues you can infer this fact by pulling and citing to other records. Of course, this court has made that clear. Substantial compliance inference is not permitted. It is a very strict and careful requirement. And when this court looks at the transcript, there is no way to find the definition as set out very clearly in Title 15 that household member is established. And so that on
Ms. Turner, should the court have just said, do you agree the state could prove beyond a reasonable doubt that the complaining witness or the victim, however you want to classify it, was a household member? Would that have been sufficient?
I think that if it was linked to the definition of the household member, it's not a generally known, but here a very technical one. So household member under Title 15, of course, has that list of meanings. And so that is the issue here. The state says close enough. There's some references to children. That's not close enough. Not only is it not in the statute enough to just have it admitted that they have children together, it has to be a sexual relationship. It has to be living together, right? These are in the disjunctive, but none of it was established on the record. And so that should have been reversed. It should be reversed on that. The obstruction of justice felony guilty plea, similarly flawed. Nowhere in that Rule 11F plea colloquy is it established that the specific intent required and that omnibus provision that the state charge here was met. Corruptly endeavors is a specific intent crime. Now the state alleges that the pure speech crime here, right? That's what these statements are, is pure speech. Is supporting the inference of specific intent. But when you look at State v. Fucci, which is the decision the state relied on, corruptly endeavor there was inferred, or actually the admission there was about the plan to kill someone. Here you don't have anything like that. Here you have someone who is frustrated, for sure, using profanity. That was not in dispute. That is not enough to get you to a serious felony, a felony offense with a specific intent requirement, particularly where First Amendment concerns are made. And so that record is insufficient to support this. Going to trial and on the aggravated domestic assault, we have what happened there after jury verdict. The enhancement portion of the trial ensued, and that was just before the bench. And the state attempted to proffer its witness to make its case for the prior conviction. And there the judge said, that is hearsay, inadmissible. Now, had the judge stopped there, we wouldn't have this reversible error. Where the court overstepped was then laying out to the state how to make its case, to get to that enhanced felony. This crosses all bounds. The state points to this as reasonable, discretionary authority of the trial court, rules of evidence, and this in no way is within that bounds. This is not a neutral act. This is stepping in, guiding the prosecution how to present its case in chief, not case in chief, but its case here on the prior conviction. There was no.
And with that, we'll have to leave it there as your time has expired, counsel.
Thank you. Thank you.
Thank you. All right, counsel for the appellee, please introduce yourself and your client, and you may proceed with your argument.
Good morning, and may it please the court. My name is Evan Meenan, and I represent the state of Vermont, which in this case is asking the court to affirm appellant's convictions for obstruction of justice and 3 counts of aggravated domestic assault. Turning first to the factual basis for appellant's pleas in dockets 3005 and 2797, it's the state's contention that the factual basis was sufficient. And it's not the state's position that it's asking this court to affirm on the basis of substantial compliance with Rule 11F. That is not the state's argument at all. Rather, the state's argument is that the appellant's admissions to the factual basis need to be viewed in their full context and with common sense, as this court mandated in its Fucci decision. And in evaluating the factual basis, it's important to keep in mind what the purpose of that requirement is. And the purpose is to prevent a defendant from pleading guilty when the conduct they're admitting to is not actually illegal or does not fall within the charge as filed. Those purposes were completely satisfied in this case. Turning first to the aggravated domestic assault conviction, there are 2 separate terms that are important to look at. The first is household member, and the second is family member. Now, household member includes individuals who, for any period of time, are living or have lived together, who have shared an occupancy with one another, or have a sexual or romantic relationship. Family members is an equally important term because, as this court defined it in Embry, it includes a group of people consisting of parents and their children. In this particular case, the defendant admitted that he and the complainant were in a relationship, and he used that term, quote, relationship, in the context of explaining that they were not married. However, that admission needs to be viewed in context and with common sense, as the state has argued. And as part of that conversation, the appellant also admitted that they had 4 children together. They were staying in an Airbnb when the assault occurred, and he had committed a prior domestic assault against the complainant, which is important because he could not have committed that domestic assault if they were not family or household members. This admission is sufficient to establish that he understood, which is what we're looking at, whether or not he understood what he admitted to and that it was a criminal offense. But his admissions were sufficient to establish that he understood that relationship meant sexual relationship and that he and the complainant were household members and family members. Turning to the obstruction of justice colloquy, that too is also sufficient. And it's sufficient specifically under the omnibus clause of Vermont's obstruction of justice statute. A factual basis under this clause must establish that the defendant has some knowledge that his actions are likely to affect a judicial proceeding and that his endeavor must have the natural and probable effect of interfering with that proceeding. That language also comes from the Fucci decision. Here, the appellant expressly admitted that he acted with, quote, wrongful intent to interfere with a trial, to put pressure on the complainant, to gain an advantage that was wrong. Those qualifiers to his admissions established that he acted with the requisite intent when he was screaming at the complainant to recant her disclosure. In addition, the Coleman decision is distinguishable because that case was about whether or not the defendant's admissions were sufficient to establish that he threatened the complainant. However, in this case, the state's position is that the factual basis was sufficient under the omnibus clause of the obstruction of justice statute. and therefore the Coleman decision shouldn't guide this court's decision in this case. I see I have approximately 1 minute left, and absent any questions, I'd like to turn to the issue of the certified copy of the docket disposition report. The prohibition on sua sponte decision-making is designed to provide parties with notice of the issues that are going to dictate the outcome of the litigation. That purpose was sufficiently satisfied in this case because the appellant acknowledged that he was going to raise the very same issue that the court raised on its own. Consequently, he had notice that this was going to be an issue because he was going to make it an issue. And the court's resolution of that issue was a fair resolution of an evidentiary issue, just like any other evidentiary issue. And the discretion with which the court operated was not abused because it falls within the court's authority under the rules of evidence 611 and 102 to guide the presentation of evidence to ensure a timely and just resolution of the case. Thank you very much.
All right, thank you very much. Your time has expired as well. Bailiff, please call the conclusion of the case.
The next hearing for the court will follow immediately.